Hello, Tero Kivinen. I'm not going to bother with the introductions because Vero very kindly took care of those. So yeah, I want to talk today about the animal laws rhetoric. And in a sense, if I had to really boil down what I'm going to do with this presentation, I'm going to start with the argument that animal law, as the title already says, animal law, whatever that means, is rhetorical, whatever that means. But don't worry, I'm going to define both in a moment. And once I've done that, if not to your, then at least to my satisfaction, I'm going to move on to sort of the question of what we can do with that information. How do we employ that knowledge and work with that in developing animal law scholarship and so on and so forth. And I might add, by the way, at this point, that it's both a curse and a blessing, but I suppose mostly a blessing to be able to present last here, because I've been able to incorporate so much of what has been said here during the all the presentations. I've been particularly happy with a lot of discussion. I'm going to connect it to at least some of the presentation even today. So I have a slight glimmer of hope that this is going to be favorably received, but we'll know in a moment. Anyway, I'm going to start with definitional stuff. So one of the argument is I just claimed that animal law, whatever that is rhetorical. So let's start with the definition of rhetoric. And fun fact, I've heard people talk about rhetoric. I think Gary Francione mentioned rhetoric. I've seen the word rhetoric on a bunch of slides here over the past 2 days. If I could get a penny for every time I've heard the word rhetoric over the past 2 days, well, I would probably have like 4 or 5 pennies to rub together. And this is not a criticism in a sense, because this is everyone working in the field of rhetoric knows this full well, that their rhetoric has a really bad reputation. We're completely, we understand that it's for a good reason in a sense. Most people, I would argue, use rhetoric in a sense that it's something void of substance. It's mere form and nothing of substance, empty words, empty rhetoric, just words. I want to go with something different. I'm going to go all the way back to the legendary dialogue Gorgias by Plato, where the parties to the dispute, before they kind of part ways, and Plato or Plato's character Socrates comes up with these kind of signature criticism of the art. They have this, small moment of sort of, that they agree on the proper definition of rhetoric before they then part ways and, discuss, whether it is honorable or not. They agree on rhetoric, and I suppose for most people working in the field of rhetoric is primarily the art of persuasion. It is the artificer of persuasion, as Socrates here puts it. It's about producing persuasion in the minds of the hearers. So it's essentially, and you're going to find a similar definition here and there, basically. It's about effective speech. It's a speech or writing that seeks to persuade some kind of an audience to do something or think about something in some specific ways. Now, that's going to be my working definition of rhetoric for the time being, and I'm going to turn now to the definition of animal law. My usual Euler diagram for discussing the various meanings of animal law. I'm going to talk about this in depth in my PhD thesis, which is hopefully going to be finished soonish. But I've noticed that during my time as an animal lawyer, animal law scholar, is that people use the word animal law and they speak of really different things. It's actually the same with rhetoric. It's the same with the concept of species in biology. But when I say that animal law is rhetorical, I have 2 of these in my mind, but I'm going to briefly cover all of them just for the sake of completeness. So I think most of the people here in the room will agree, and this is kind of I suppose a palatable interpretation, is that animal law is a branch of law, right? That's the way most people in literature seem to define it. Animal law is kind of the sum of legal materials, rules, principles, cases, institutions that have something to do with animals. So it's the law as it is with regard to animals. And then we can move forward and problematize, so what are animals? What exactly counts as law? What's the necessary connection between the two? How much does the law have to pertain to animals to count as animal law? But that's the first definition. Let's go with that. Secondly, and this is going to be just a very brief mention, I'm going to spoil already, or a teaser, that the second operative meaning is going to be advocacy. That's my number 4 here. But animal law is also about practice. In fact, I think this is, to my mind, it seemed that this was what Gary Francione seemed to have in mind when he spoke about animal law in scare quotes yesterday and sort of criticized it, is that animal law can also be understood as practice, practical efforts, legal services that have something to do with animals. And then we can agree or disagree as to whether it's about, nibbling at the edges and being systemically incapable of changing anything in the world, really. But yeah, that would be my second definition. Thirdly, I probably don't have to argue this all that much, animal law scholarship. I mean, I'm here in my capacity as a researcher of animal law, giving a talk in a conference on the theory of animal law. So apparently, arguably, animal law is also a field of scholarship. It's scientific, dare I say, academic activities that try to make sense of the human-animal relationship. And then fourthly, and perhaps most importantly for this presentation's purposes, animal law, I see there's a clear activist, if I dare say, element to animal law. We don't just discuss the law as it is. Many here in this room, I would wager, have very strong opinions as to how the law ought to be. People engage in various kinds of arguments, they draft treaties, they draft legislation, lobby, they file lawsuits in an effort to improve the legal and societal status of animals. So that would be my second operative definition of animal law for this presentation. Now, tying this all together in a nice, logical conclusion, I hope anyway, when I say then that animal law is rhetorical, this is what I mean. So animal law, both in terms of the law as it is, as well as our arguments as to how the law ought to be, are rhetorical in the sense that in the first case, it's more perhaps about the outcome of rhetoric, of successful rhetoric. Someone somewhere at some point in time made an argument as to what the law ought to be, and that was the winning argument, and hence we have the law as it is, and then we can study it for its rhetorical characteristics. But I suppose, because I've been in talks with people here, and we had an agreement with at least some people that it's more interesting to talk about what should be done with information, not just knowledge for knowledge's sake, then I suppose I'm going to focus a bit more on what we can do with this information, so animal law advocacy in a sense. And I think that's the easier case, to be honest. I mean, what else would animal law advocacy be if not rhetorical? If the point is not to persuade an audience, judges, legislators, whatnot, the population at large, then why would we even bother with it? There's clearly, it seeks to persuade an audience to do something, enact some kind of change, or think in a certain way about animals. So by now, I hope to have convinced, if not you, then at least myself, that animal law, as I define it, is rhetorical. And now I'm going to turn a bit more towards, what we can do with this information. In this regard, I had the pleasure of chairing yesterday's first session, where Celia, hello Celia, did the first presentation there, and I see that there's kind of I perceive anyway, maybe you agree with me, maybe you don't, but we're kind of in the same business in a sense that this is essentially what I'm doing here. I'm trying to sell or peddle a methodology, a way of thinking about animal law. In my case, it's probably not a new one, it's not a new framework, but I do believe it's kind of underutilized in the sense that if this is what people want, there are clearly persuasive elements to what animal lawyers do, then it would make a lot of sense to understand the kind of theory that regulates or at least tries to describe persuasion. How does it work? What are the do's and don'ts of persuasion? What kind of things should we do if we want to win audiences over? Now, regrettably, rhetorical theory is way too vast to go through here. I mean, it would encompass pretty much anything. Well, there's plenty of elements that could be used, but I'm going to focus on two sets of categories that I think might be most fruitful for talking about animal law and figuring out, what we could do in terms, what kind of strategies, what kind of different appeals or means of persuasion animal lawyers, animal law advocates could do or could utilize in their quest for making the world a better place for animals. The first one are the so-called technical proofs of rhetoric. So one of the basic premise of rhetoric, in a sense, is that there's not just one kind of method of persuasion. There's three. So there are three different ways in which we can try to persuade audiences. There is appeal to character, ethos. There's the appeal to reason, logos, and there's the appeal to emotion. Sound familiar? Pathos. And I regret I'm not going to be able to go through all these in detail, but maybe I'm just sort of musing what I would like to do with this framework in the future, but also connecting it to some of the arguments I've heard here over the past 2 days. Ethos, first of all, typically, so this is the appeal to character, the idea that we're likely to believe people we perceive as credible, right? If someone appears as, I don't think incredible is not the right word here, non-credible, uncredible, I don't know. we're less likely to believe what they say, less likely to do what they want us to do. But whereas on the other hand, if people have impeccable authority, we're likely to believe them, even though perhaps their logic might be flawed or there might be something fishy going on there. What I perceive as problems, perhaps in a sense, or let's start with the strengths. I think ethos-wise, animal lawyers are in a very, very good position in a sense that ethos tends to be split into further constituent elements in the sense that it comprises virtue. Virtue in the sense that it's about the values, the apparent or supposed values of the speaker, in the sense that audiences are more likely to believe speakers that seemingly at the very least believe or share their values. Secondly, though, there's also so-called craft. You could speak of craft or practical wisdom in the sense that it's not enough to appear as a virtuous person. You should probably also know what you're doing, right? People are probably more likely to believe someone, a lawyer, for instance, in legal matters, who, lawyers are specialists in legal matters. So in that sense, I believe that lawyers have a fairly easy time with ethos, the ethical appeal. And thirdly and finally, and I think this is also something where animal lawyers do pretty well, is the third constituent element of ethos is, I could say, goodwill or disinterest, in the sense that the speaker or the writer should at least appear or give the impression that they're advocating not their own self-interest, but what's in the best interest of their audience. And I think, following, for example, the discussion in the voiceless seminar, be it the kickoff event before this, and plenty of the other arguments here, by the way, as well, I think we're doing pretty well in this regard, that much of the arguments, the animal interest arguments, can also be sort of cloaked in terms of human interest. It's not as if the selfish animal lawyer is advocating only for their own self-interest or the interest of animals, completely against the interest of humans. Quite the contrary. There's been a lot of talk about the overlapping interest, these points of convergence, in the sense that we could do away with plenty of animal exploitation, not purely out of animal interest, but because it hurts us as well. So there's a lot of convergence in that sense. I think, I've got to move on forward really quickly. I think the greatest weakness, I'm going to connect it to, this to logos, in the sense that logos is the logical appeal, which I'm not going to go too deeply into. I'm going to write more about that in my PhD. But I think the problem here, and I'm going to connect this back to what David said in his keynote earlier today, is the problem of logic. I don't really maybe disagree with you in the sense you said some of the, let's say, political developments in America recently could be characterized in the sense that people are not doing the logical thing anymore. They're doing something different. I think we could, though, perhaps characterize it that there is a logic. It's just not a logic we're kind of happy with. It's a logic. It's not a logic of self-interest, what's in our best interest. It's certainly not a logic of, what would be in the best interest of the environment or animals, for instance. It is a logic of hate. But, it can be characterized or restructured logically that there are principles out there in play that do kind of logically lead to these conclusions that we disagree with. And that's kind of one of the challenges, I think, the biggest challenges logic-wise for animal lawyers is the sense that in this room, I would probably not have to work all that hard to convince people of the moral argument that animals have rights or animals ought to be treated better. But we're not the entire political populace, right? I mean, we're not representative of the entire electorate. Most people probably don't share our values, so that's something that I think we need to take seriously, and something that. And I should add, by the way, that all of this is really, really complementary in the sense that this is not me saying that some approaches are completely wrong. I'm simply suggesting that different audiences require different kinds of approaches. They will believe in different kinds of things, and the argument is going to stick all the better if it can play off the beliefs and values of the audience. And then it can be complemented with other things. Again, like the appeal to character, the personal credibility of the person doing the argument, and finally pathos. I'm going to connect this back to what Morgan was talking about recently, the role of the emotional. I mean, it's something that we might despise in certain genres of philosophical debate, for example, that everything should be reason-based, everything should come down to logic, but let's be honest, as David did point out, that there's a lot of emotion at play in politics. People don't do what seems to be the logical thing. There's a lot of emotion at play, and that's something that is Probably not, well, not probably, it's completely unacceptable in certain genres of philosophical debate, for example, but it is completely okay and legitimate. It is part of the toolkit of rhetoric, and it should be understood and, used to the advantage of the animal lawyers. And I got to be really, really fast with this one. I think I have 5 minutes on my clock, 5 minutes roughly, yeah. Another set of categories that I think are useful for characterizing or classifying instances or maybe making sense of animal law rhetoric are the branches of oratory. So again, just like rhetorical theory believes that there's not just one kind of appeal or one method for persuading audiences, there's three. Likewise, there are three kinds of branches of oratory or three different genres of rhetoric. And to go really, really briefly through them, I'm going to have to summarize this. Maybe the easiest way to go through them would be in terms of temporal orientation. What are we really talking about? So when we're talking about past events, we're typically in the realm of so-called judicial or forensic oratory. This courtroom rhetoric. It's about talking what happened in the past. Was it right or wrong? Was it an injustice or justice? Was it legal or illegal? Ceremonial is probably the easiest to define in opposition to the two others because it's so messy in a sense, so I'm going to jump right into the third one, which, by the way, I believe animal law rhetoric is an instance of political or deliberative oratory. The kind of oratory that takes a view to the future. It's about choices. What should we do with regard to the future? And then just to briefly, for the sake of comprehensiveness, so ceremonial oratory is the odd one here. It's the oratory of funeral orations, graduation ceremonies, political rallies. It's about praising a political candidate or blaming the political opponent. It's about talking about values, virtue, vice, that kind of thing. And I think this categorization is also, in a way, I'm not saying, and nothing here again is suggesting that it's only acceptable to use one strategy in argumentation. I mean, Aristotle himself, who came up with this, was really, shrewd enough to notice that we can use other kinds, not just the special, so-called special topics, or the kinds of things that we should be talking about in connection to each of these discourses or types of oratory. We can use the others, but they should be more in a supportive role. So for instance, and especially with in terms of political discourse or political rhetoric, when we're addressing some kind of an audience that has the capacity, the power to enact change, whether it's a legislator, a member of an assembly, or even perhaps a judge. We shouldn't take that mention of judge too seriously here, by the way, because judges, I mean, that's the whole point, I think, of personhood cases, is that it's about the future. It's not, I mean, the NHRP is not argument. They're not trying to condemn what happened in the past. They're trying to make something out, map a future for the animals, do something with regard to the future. And in that case, the judge is the proper addressee of that speech. But so rhetorical theory, in really, really briefly, the special topics or the preferred topics of this political oratory, which I consider animal law discourse or animal law advocacy to be an instance of, it's about the advantages and disadvantages. And it's something that people have been talking about all over the past 2 days, in the sense this interest convergence, the overlap of human and animal interest, that when we try to do something politically, values do play a role, questions of what is moral, what is immoral, that kind of stuff. But it's much about convincing the assembly, convincing the audience, the voters, for example, of what would be in their best interest. This is what the theory holds anyway. And this, I think, is a very, very good argument in the sense. So again, this is complementary. It's not saying, and none of this should be construed so that I'm saying that people should drop the moral argument altogether. That's not at all what I'm saying. I'm saying that if you want to achieve something, and this is part where I'm going to commend David, by the way, for the new Convention on Animal Protection draft, in the sense I was really, really happy rhetorically to know the huge emphasis on COVID and pandemics. They're a really smart move. I like that. And I think it's a really, really good instance, an example of the fact that there's plenty to be achieved. As you yourself said, that this is a really, really great opportunity for taking something that has had a huge negative impact on humans and trying to make something positive out of that for animals, to try to get some kind of international regulation for animal welfare, even if one of the driving forces then would be human interest, not just the interest of the animals themselves. I'm running out of time, aren't I? I hope that made at least some sense, Thanks for listening, and I suppose I'm open for questions and comments. Thanks.